not just the one time and saying, oh, well, you don't have to spend the house down to qualify for Medicaid, dad. We want to also protect mom and make sure the house makes it down to the kids because that's what our clients want. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to the video. Today we have a very special guest. We have David Cole from the Senior Veterans Council, and we're going to be talking about how a lot of even Medicaid planning attorneys are not looking more than just one step ahead, and they're not doing nearly the type of work that they can do to protect the assets for the family when getting their client qualified for Medicaid. And this is coming out of a blog and also a video that I did a little more recently. But I think David and I work together very closely on a lot of these cases, and we have seen a whole bunch of stories over the years. And I think we can kind of communicate and hammer these things home. We've got five big things, but we can probably add a few to those as well. So, again, for those who don't know, I am Jeffrey G. Marsocci, the plain English attorney. I am also a certified Medicaid planner, and I have been doing this for more years than I care to mention on a recording. So I've authored several books, and we have some online courses to help with the basics. One of the big things I always want to make sure that I'm doing, not just for my clients, but for the general public, is to put good information out there on estate and Medicaid planning. So I'm going to just turn it over quickly to David to introduce himself, and then we'll start looking at these five big things and see what else we can add to them. So, David.
Yeah, well, I'm a benefit planner with the Senior Veterans Council, which indicates that our focus is on senior wartime veterans and widows, but we also deal with folks that are not connected with military service. So I'm a privately accredited VA claims agent, and also accredited by General Counsel out of DC, but also a certified non-attorney certified Medicaid planner. Uh, so yeah, in that work, Jeff and I again work together to kind of dovetail those benefits and coordinate them, and again see a lot of different odd things that happen with other professionals.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Yeah. So let's jump right into the big one that we unfortunately see all the time. And this is kind of deficient powers of attorney, whether it's a financial or healthcare. Usually the financial end is where it's a little bit deficient. But the big thing, they only have one person listed as an agent. Now, I don't know how much you see of this, David, but when I see estate planning, at least I tend to have the estate
Mhm.
planning attorney, they'll put in one alternate. But for whatever reason, a lot of the times when it's specifically Medicaid planning, they're just listing the spouse, or if there is no spouse, or they've already passed on, one kid. And that's it. Just that one person. Well, look, life happens, things happen to people. So, that agent could pass on before them, especially if it's a spouse. Now, this was a statistic that I came across. 60% of the time, the caregiver spouse goes first. Well, if the only power of attorney is that caregiver spouse and they go first, 60% of the time, you end up with no power of attorney at all. And then the reaction is, oh, well, go to court and get a guardianship put in place. Well, now suddenly you have the court overseeing and looking at everything that you're doing. Everything needs to be accounted for down to the penny with multiple backup paperwork and stuff just to justify everything. And it becomes a lot more complicated than it needs to be because they didn't put in a couple of contingencies in that power of attorney. It's crazy to not
Yeah,
have backups.
yeah, crazy is
So
a good word. Yeah, crazy is a good word. It just, I don't, yeah, exactly for all the reasons you just said. The other thing I'd add is creating, okay, yeah, we'll have two, but we'll make it, what do you call, joint decision. So that is
yeah,
unworkable. And might explain why that. Let's not put on there that it's a joint where you've got to have two people involved while one is on vacation in Europe.
Well, and that's the thing. It's the same thing when it comes to estate planning or Medicaid planning with trustees. Oh, let's have co-trustees. Let's have co-powers of attorney. Let's have co-executors. And I think it's because people are assuming, oh, well, if I have co-powers of attorney, they can spread the work around. No, if you have two co-powers of attorney, or God forbid, three, you're doubling or tripling the paperwork because financial institutions are insisting that everybody sign everything. So, yeah, you're not spreading the work around, you're multiplying it. And this is something else that I came across recently as well, more in the probate field. And David, I don't know if you've come across this. There are a lot of banks now that will not open estate accounts if you have co-executors and give both of them authority.
Mhm.
And they kind of have to. It's like, okay, you've got three co-executors named in a will. They won't even open an estate account and put those three co-executors on it. They just won't do it.
Or they have to
So
run it up
now,
to their legal department, which then bungs it up for 6 to 8 weeks.
yeah, yeah, it's just so much easier and it manages things so much more smoothly if one person is in charge at a time. But just because there's one person in charge at a time doesn't mean you shouldn't also put in those backups.
I don't
So
know if
another
the
thing,
intent, yeah, I don't know if the intent is to say, oh, I don't want, you know, my son John to do something without Bill's approval. Well, if you've got that problem, you probably have deeper problems.
yeah, and sometimes when I do see that, the real issue is, well, Tom is the oldest, but Bill actually financially is the smartest. But we can't not have our oldest child in charge. That just doesn't seem right. No, 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 no. When it comes to things like this, powers of attorney, trustees, and whatnot, you put the best person for the job. This isn't about
One,
who you love the most or who's the oldest. It's about who's going to do the best job. So, what kind of problems have you seen with either not having enough agents or potentially co-powers of attorney? I mean, have you ever worked in your office with multiple people trying to tell you different things, but they have equal authority?
yeah, exactly that. And what I mentioned earlier, it's where the one of the kids are in Europe on vacation, and oh, we need a wet signature. Well, how are we going to get that over in Europe? And FedEx,
Yeah.
or it's still no. I see no value in co-trustee, guardian, whatever. No value. It just usually very complex. No value and nothing but problems to do that. So absolutely,
Yeah.
that's got not. I don't. What's the value in having co-trustee? I don't know.
There is, I don't see anything. Um, yeah, I don't see any value in that.
Mhm.
Now, the way we do things, which is definitely different than that, I try to insist on at least three people in succession,
Mhm.
potentially having a company in there as a backup after the three people that you've named. But even more importantly, when we look at the documents, it's not just a power of attorney, it's various trusts. The power of attorney list is the same as the trustee list, same as the executor list. Excuse me. Right. So you've got that same list. And then even if you run through all three of them in at least one of the trusts, there's a process for choosing the next person or the next person or the next person. And the power of attorney and the will and the other documents reference that trust. So whomever is the trustee that gets chosen also becomes that agent, because it's kind of important to have it go to exactly the same people so that one person is in charge of all the financial things. They can get whatever help they want, but it's never two or three co's. And we don't just leave it at one person. We look several steps ahead.
Well, by the way, yes, same name on all the financial estate instruments, but it can be different for the healthcare power of attorney. You may have a different set.
Oh, that's definitely something that's a little bit different. It's an entirely different skill set at that point. You know, I this will tell you a little bit about how long I've been doing this. I used to say, well, look, you can have someone who's just really good with making healthcare decisions. They kind of live in that field, but they can't quote balance a checkbook. Well, I've been told pretty recently by being laughed at, "Yeah, people don't balance checkbooks anymore. It's automatically done online. You can just check it and make sure that the bank didn't make a mistake, but you're not quote balancing your checkbook." Okay, but the point is, if they're not good at finances, that doesn't mean they should be precluded from making the healthcare decisions, because it's an entirely different skill set. On the other side of it, oh, you've got someone who's really good with finances, but they are just not in tune with the type of medical and healthcare decisions that you would want made for you. And so you want to keep them off the list. I have a lot of clients that occasionally struggle because they're trying to find Superman or Wonder Woman. They got to be able to do it all. Well, no. One person, list can be for financial, the other can be there for healthcare. Not everybody is good at absolutely everything. Right. So that's the first big point. The second one, oh gosh, this is just not doing anything to look beyond the one client. If you've got a husband and wife and they own their home and they own it as tenancy by the entirety, the tenancy by the entirety is joint with the right of survivorship, but for a married couple. Yeah, one spouse can qualify for Medicaid, no problem. All right. Well, then what if the spouse outside the facility passes on? Well, now suddenly that house is there. It's only in the name of the person who's receiving Medicaid. And now Medicaid can put a lien against the house. Well, why would you advise someone to do that? Transfers can happen between spouses without any kind of Medicaid penalty. So why not at least get it into the first step, get it into the name of the spouse? Okay. The other spouse gets qualified for Medicaid. All right, then we should be able to move it into something like an irrevocable property trust so that it takes it off the table 5 years down the road in case the other spouse also needs care. We're looking at these several steps ahead to make sure we're preserving the house, not just the one time and saying, oh, well, you don't have to spend the house down to qualify for Medicaid, dad. We want to also protect mom and make sure the house makes it down to the kids because that's what our clients want.
Well, like you said, it's looking ahead for that extra step to avoid problems because it happens. I mean, unexpectedly, the commute or the at home spouse dies. You didn't expect that. Now what do we do? And all of a sudden, she owns the home, and kicked off. It's exposed to a lien and recovery. So yeah, let's avoid that.
Right. So we got to make a couple of extra steps to make sure that we're doing everything the right way, thinking about all of these potential horrible things. Look, I sometimes sound like Mr. Doom and Gloom when I'm going through the estate portion with my clients. It's like, well, what if this person dies, or what if this person dies, and then what if they die? It's like, okay, I sometimes get clients that are like, oh my gosh, if all those people are dead, what do I really care? Well, okay, then we can put in some contingencies there, but we have to go several layers deep. It's the same thing when doing the Medicaid planning and the potential shifting of assets. It's like, well, okay, we should probably think and at least have some potential pivot in the plan so that we If something goes the way we don't expect, there are other options to keep things and keep the plan on track, or at least the goals on track. When you just throw your hands up and go, oh, we're just going to do it like this for this one person, then that's not really doing what our clients want. We really want to make sure we've got several things planned out with different contingencies. And so, especially with something like the family home, that may be the most important item other than the family members and the kids that they want to pass along.
Yeah, what people don't understand, there's a difference between getting qualified for Medicaid with these simple steps, but then losing the asset because of a lien, because of the failure to think ahead. So, yeah, always think, wait a minute, it's not just getting Medicaid, it's avoiding Medicaid recovery.
That's a big thing. And uh, each state can put in place some of its own rules within certain parameters. So, I don't want to get too deeply into this because we do kind of have a little bit of a national audience, but for some states, there are things that we can do to help avoid that recovery while still qualifying. But there may be, depending on the state, some more a limited number of options, but there are still options. There's always something that we can take a look at and potentially do. All right. So that's
Let
the
me
second big. Yeah.
to clarify, Medicaid recovery is the concept that where the rules say that yes, mom's on Medicaid, and yes, the state is going to pay the bill, the $15,000 a month bill, while she's in the facility. Well, oh, wait a minute. When mother dies, the state has the ability to turn back to mom's estate and say, wait a minute, we just paid out $200,000 of the state's money. We have the right to recover. That's what they mean by a state
Mhm.
recovery. We have the right to recover the state's money by looking at mom's estate and other assets to say we want to be paid back, and we could put a lien on it or a demand. So that's what it means by a state recovery. So hey, it's one thing, yeah, we went to an attorney, they got us on Medicaid, but wait a minute. Years later, mom dies, and now that what we all of a sudden that money we thought we had saved is not going to be there.
Yeah. Yeah. And that's the big goal. It's not, oh, I want to make sure I don't have to sell my house right now to get Medicaid. It's I want to preserve it for the family.
Yeah.
So that's almost not even meeting the bare minimum of the client's goals is to save the house for the family. It's no, I got you qualified, but yeah, the state will come back at some point and take it away from the family.
Mm.
All right. So, all right. So the third thing that I see a lot of Medicaid planning attorneys just kind of fall a little bit short. If you do have a couple, you're only doing legal documents for the spouse going into the facility. All right. So, I mean, it's bad enough if you're doing a power of attorney or a healthcare power of attorney and you're only putting the spouse in, you don't have contingencies. But look, the spouse also needs to have documents in place. What if something happens to that spouse outside the facility? They have something happen to them and now they need care and there's no power of attorney documents, or the power of attorney documents are not sufficient, or it's one of these downloaded things. Really, if you're doing Medicaid planning for a spouse that's going into a facility and they are you're putting together documents for them, there's no reason to not also do something for the spouse who's not going into the facility just in case something happens. So, David, have you seen any circumstances where, yeah, the professionals just ignored the documents that the other spouse would have needed?
Yeah, I wouldn't say regularly, but yeah, you see it and you wonder what were they thinking? What
Yeah.
what why not? I mean, you're in the middle of doing it, but for all the reasons you just said, and I've seen exactly what you said, that where all of a sudden that trigger occurs and you're left Now what do we do? And the at-home spouse is incompetent. You can't get a power of attorney because of a stroke or a setback. And wow, what a mess! All because somebody didn't think it through or do a thorough job, I guess would be the word.